Alright, so why would you want to go to a settlement without doing litigation? Well, obviously, I think I've mentioned this before, but costs. Going to litigation is expensive. Attorney's fees are expensive. You're looking at, at least with my firm, $300, $350 an hour. All right, and that's even just to sit there and wait for the case to be heard. That gets very expensive. Court costs. Filing a litigation isn't that expensive. I mean, it's a couple $100, but still, it's a cost. So why go through with those costs if you can resolve the matter without incurring costs? So that from a business perspective, that's a good thing. Personal reasons. Compromise is instinctive. Folks, think about it. Do you really want to be fighting with your friend, your neighbor, your business associate, etc., etc.? No. I know that anytime my wife yells at me, it's my fault and I've done something stupid. I know this, so what do? I try to resolve it. If my wife says, "God bless America, Mike, why didn't you take out the garbage?" I just go grab the garbage and I take it out. Why? Because I don't want to fight with my wife. It's not worth it. If my boss says to me, "Golly gee, Mike, why didn't you file that brief this way?" Well, it's already been filed, so I'm screwed. However, boss, I'm sorry. I'll do better next time. I'll add that item to my toolbox. Okay? Dislike of trouble. Folks, nobody likes trouble. And believe me, litigation is a hassle. Alright? I mean, I enjoy doing it. However, I would much prefer to, take the money that is used to retain me, resolve a dispute, and save my client a few bucks. I mean, that makes me feel kind of good. Opinion of others. Alright? Certainly, whenever you're talking to your attorney, the best thing you can do is listen to your attorney, especially when they're giving you legal advice. All right? Believe it or not, attorneys know what they're doing. If they tell you, "Hey, you may want to settle here," settle. All right? The rationale being is the attorney knows the system. The attorney knows what might happen in court. If you sue someone for $10 million and they offer you, $5 million, go settle. Settle. Okay? That's a no-brainer. Okay? Business reasons. Certainly, if you're being sued and you're a business, you might want to avoid going to litigation because of the publicity that comes with it. Is it bad for business? Is it going to hurt your reputation? Could there be sympathetic jurors? Meaning, oh my gosh, you built a TV and it blew up. Settle it. Okay? Don't go to litigation. Settle it very quietly. Get her done. And don't have your TVs blow up. Now, what are some other methods we can use? Well, arbitration is one. Arbitration is fairly popular. You'll see it in a lot of standard contracts. Basically what happens is a third-party arbitrator makes a final decision. You go before the arbitrator, and generally speaking, it's going to be a panel of arbitrators. You can do mandatory or voluntary, meaning that you are mandatorily required to go there. The court says go to arbitration, or voluntary, meaning the parties agree. The final decision is binding. It comes in the form of an award. Now, why would you want to do this? Well, just like with just negotiating an issue, it's an inexpensive form of resolution, right? And it eases the court dockets, and you get expert assistance, meaning that the people that are on the arbitration panel are, generally speaking, experts in the field that they are reviewing. How does this occur? Well, parties agree to arbitration. Generally, it's going to be written. If you read a lot of contracts, you will see that within the contract itself, it says the parties hereto do hereby agree to go to binding arbitration in the event of a dispute. All right. Now, keep in mind that doesn't take away your ability to litigate. However, you must go through arbitration first. Specific matters agreed to arbitrate. Certainly, as you get closer to arbitration, you will know what the issues become. Matters for arbitration: questions of fact, questions of law, questions of fact and law. Okay? And again, it's very similar to going to litigation, just not quite as structured. Now, there's a trend toward arbitration, and you can see why. Judges don't have time to handle every single dispute. I mean, even though, as the book points out, 95% of cases settle before going to litigation, you are still talking about a voluminous amount of material that is out there that the judges have to hear. I mean, divorces, contract disputes, criminal issues, property disputes, all of these things, if they can't settle, have to be heard by judges. And I mean, think about it. These things, to present evidence and go through litigation and just the trial process could take several hours per event. So if you only have, 4 or 5 judges, or in my case, 3 or 4 judges in a county that can hear these things, they get backed up. One more reason why the wheels of justice move oh so slowly. Arbitrators. Expertise. Certainly they are going to have a certain area of expertise whenever they sit on that arbitration panel. Number chosen. Generally speaking, I've seen 3. Authority over certain matters by agreement. The 2 parties that are coming to the arbitration will agree to what needs to be arbitrated. So Peter Beckman, there he goes. Peter Beckman and Whiplash will say this is what we're going to discuss. Alright, so awards. Everyone loves awards. We love money. Disclosure of findings and reasons. Not needed unless required by statute or agreement, and parties are bound by the award. Court favors award and broad scope of authority. Keep in mind it's final on submitted. Issues are filed with the clerk of court and enforced by the court. Alright, so again, there is some authority that goes along with arbitration. Federal Arbitration Act. Read through this a couple times. It's pseudo interesting. It was enacted in 1925 and 1947. Covers any arbitration clause involving interstate commerce. Obviously, interstate commerce is anything that involves commerce. Everything. Impact on policy. Court assumes intention. May set aside state laws under commerce and supremacy clauses. So again, there's other things out there, and it allows for, there's rules out there that allows for how arbitration should be handled. Now, mandated arbitrations. States are starting to adopt this. It speeds up the process. There are many qualified arbitrators that can handle this type of thing. Cases are going to be less than $15,000 and have a specific subject matter. Record of proceedings is required. Now, how do you go through this? Well, you submit your claim. Okay. Again, it's going to sound very similar to filing a lawsuit. You go through the discovery process, gathering up all of your information. Arbitrator determines the admissibility of evidence, the law and facts of the case, and listens to any objections. All right. Then you have your hearing. Okay. And the arbitrator listens to everything and makes a decision. Voluntary contract-based arbitration. Pre-dispute arbitration. In a contract, parties agree to arbitrate as opposed to litigate. And again, that's what I've talked to you about. A lot of standard contracts you see today, you'll actually see arbitration clauses, and that would be a pre-dispute arbitration clause. Post-dispute arbitration agreement, parties to a dispute agree to go to arbitration. So there's not an arbitration clause in the contract. However, you realize there's a difference of opinion between the parties, so both parties agree to go to arbitration. Judicial review of arbitration, voluntary contract-based. The award is final. Findings of fact and law are conclusive. There's limited review by the court, but there are ways to appeal a decision that is made by an arbitrator and go to court. Correct fraudulent arbitrary actions or against public policy would be examples where you can actually appeal to the courts. Statutory mandated, in accord with procedural due process of law, so meaning that if you go through the arbitration process and you need to appeal it, then you have to go through the proper channels and make sure due process is carried out. Constitutional challenges, that's always fun. And when you go there and you actually are going before the courts as a result of a disagreement over arbitration, is a de novo review. And the court tries the issues anew as if no arbitration occurred. Now, judicial review under the Federal Arbitration Act, obviously it's going to be interstate commerce issues. Federal Arbitration Act applies. Arbitration award may be vacated if there was fraud involved, the arbitrators were corrupt, there was misconduct, or they exceeded their powers. So again, you see that arbitration is arguably a fairly good thing. It's cheaper, it's faster, it's final. It's enforced by the courts. However, there are ways out of it if you see situations where fraud was done, the arbitrators didn't do what they were supposed to, there was misconduct, or even if they exceeded their powers. So all in all, arbitration is not a bad thing. It's actually a good thing, and you really have to see it in action to really appreciate the value of it.